Prior consistent statements, 801D1B, prior consistent statements made by a witness is not hearsay if three conditions are met. The witness must be cross-examinable at the trial concerning the prior statement. The statement must be consistent with his present testimony, and it must be offered to rebut a charge of recent fabrication or improper influence or motive. Under the advisory comment notes, the rule, there is substantive evidence once pre-motive requirement is met. These pre-consistent statements come in after there has been an impeaching attack that raises a charge of recent fabrication to improve an improper motive. Rule is tied to impeachment by bias. Admissions by a party opponent and lows in most testimony. Rule 801D2, certain amount of out-of-court statements by a party to the lawsuit. We allow a party to introduce other parties' prior statement because no hearsay danger of insincerity, guarantee of reliability, because party has personal knowledge of the lawsuit. 5 types of statements admissible under 801D2, 801D2 as admissions for party opponent. Party's own statement made in either individual or representative capacity, a statement of which the party is a statement of which the party has manifested an adoption or belief in its truth. Advisory comment for those: when silence is relied upon, the theory is that the person would be under the circumstances protest the statement made in his presence if untrue. C. A statement by a person authorized by the party to make the statement concerning the subject, a statement of the person authorized by a party to make a statement concerning the subject. Advisory comment to this: party's books, records are unusable against him without regard to intent to disclose third persons. Next, statement of an agent of the party concerning a matter within the scope of employment. And a statement by a co-conspirator of a party during the course and furtherance of the conspiracy. Advisory comment to the conspiracy one is: court may consider contents of the co-conspirator's statement in determining the existence of the conspiracy and the participation therein of the declarant in the statements offered. Here's a hypothetical for individual admissions. Martin leaves his truck at Carter's shop. Carter employee Dugan was working with a wielding torch on a wrecked car. Paint shed burning out of the control, and the fire consumed and destroyed Martin's truck. Esther, the adjuster, told him if the fire at the point of the shed Dugan was flaming a wheel, then torch the ground too close to the fumes. Martin introduced Carter's statement as the truth of the matter asserted. How can assurance be offered to the truth when Carter wasn't even there when the fire started? There's no personal knowledge requirement. Rule accepts common law. Rule: admission not subject to requirement of first-hand knowledge. Admissions are free, or does not require that statement be within the interest when made, just when the study has to be made by party opponent. Admissions are free from the opinion rule. Opinions can be given, the statement can be conclusory. The statement will be admitted. The party's own statement manifests the belief in truth. Party's agent, if admitted, is against one party or not another. For limiting instruction, the jury will know who to consider the statement for. Consistent statements. The federal rules adopted the common law pre-motive rule. Cases say pre-motive requirement occupies the field, and you can't use impeachment for prior consistent statements like you can for prior inconsistent statements. Prior consistent statements, to get them as substantive evidence. If you can't get them as substantive evidence, they cannot get statement under impeachment or bolstering post-motive, pre-motive requirement, unlike prior inconsistent statements. Prior statements of identification have 2 elements. Declarant testifies at trial. Hey, man.
Talking to yourself in here, buddy?
Yeah, I like recording to